This conference will now be recorded.
Okay, good morning, and thank you for joining us today as we talk about estate planning for new parents in Florida. I am Florida attorney Kaitlin Wildoner, and I will be leading the discussion today. So if you have any questions as we go through the webinar, please feel free to put them in the comment section, and I will answer them as best as I am able to at the end. So again, thank you for joining me as we discuss estate planning for new parents in Florida. As is always the case with our webinars, they are for informational use only, and they do not represent an attorney-client relationship, nor should they be construed as legal advice. While I am a Florida attorney and I do this webinar is not one of those times, as it is for informational purposes only. And should you wish to set up a time to speak over the phone or video chat, please do contact us as I am happy to do that. And at that time, I may be able to offer individual legal advice for you in your situation. So now with the disclaimer out of the way, a little bit about me. My name is Kaitlin Fallon Wildoner, and I am the founder of Wildoner Law PLLC. We're a law firm based in Northeast Florida, and we've got offices in St. Augustine and Jacksonville. The division of the firm that handles our estate planning matters is known as Wildoner Wills, and that website is wildonerwills.com. And that actually just went live this week as we've rolled out a new way to make our estate planning even easier. A little bit about me, I'm a wife and a mother, and I am passionate about helping new, expecting, and longtime parents solidify their estate plan. That passion in part comes from when my husband and I were expecting our daughter, who was born last April. We went through creating our estate plan with her in mind. And during that time, we had to have some tough conversations, including who we would want to care for our daughter if we both passed away. But those conversations, as hard as they were well worth having. During that time, though, I came to realize that the old way most attorneys created estate plans required not only a lot of our time, but a lot of our money. I knew there had to be a better way, and I was determined to create it. So while I've always offered virtual planning, as I mentioned just a few minutes ago, this week we've launched our new platform to make it even easier to create your estate plan than ever before. And if you stick around through the end of the presentation, we'll discuss how you can get involved using our new platform. Okay, so today we're going to discuss what estate planning is. Then we'll have a brief discussion about whether you need an estate plan. After that, we will move into a discussion about important documents specific to parents and special considerations for parents. Last, we will conclude by talking about some of our virtual offerings that are meant to make your life easier and your estate plan more secure. So first, what is estate planning? It's a phrase we may hear thrown around, but it may be something we don't fully understand. Estate planning encompasses a lot. It includes planning for your incapacity, your death, and any medical emergencies that you may have. Within those events, estate planning covers what happens to your stuff when you pass away, what happens to your body, either when you become very ill or when you pass away, and what happens to your minor children when you and their other parent both pass away. Obviously, no one likes to think about any of those events, but planning ahead of time for them can make the lives of our loved ones much, much easier when those events happen. As Benjamin Franklin said, the only certain things in life are taxes and death, and a properly drafted estate plan can help you plan for both of those. As we will continue to discuss throughout this presentation, estate planning is particularly important for parents of minor children. Some people may not care about the mess they leave behind for their family if they, especially as a single person, for example, pass away. But most parents do not want to leave their children in any cloud of uncertainty should they pass away prematurely or wind up incapacitated and unable to care for themselves. That is why it is critical to have an estate plan if you have or if you are expecting children. So the ultimate question everyone seems to ask, even though I think most everyone knows the answer, do I need an estate plan? Yes. All adults need to consider what would happen in the event of a serious accident, incapacitation, or death. Parents are particularly sensitive to this as they have their children relying on them to protect them and care for them. So over the next few slides, I'm going to cover some of the important documents for parents, but non-parents can also learn a thing or two. An estate plan is not something for the wealthy or even just the middle class, but it's something every adult needs in some form or fashion. Your estate plan should evolve as your life evolves. An estate plan is not a static thing. The estate plan of an 18-year-old college student is very different from the estate plan of a 26-year-old accounting professional with no children, whose plan is very different from the 35-year-old parent with 2 children. You kind of get the idea. Everyone's plan is different, especially at different stages in life, but everyone needs a plan in some capacity. Some of the most important documents and components of an estate plan for parents include a last will and testament, informally known as just a will, a power of attorney, a healthcare surrogate, and a designation of pre-need guardian for their minor children. There are other documents that we offer, such as a revocable living trust, but that's not always necessary. Additionally, we provide HIPAA authorizations and living wills for our clients under our will and trust packages. A last will and testament, or just a will, is one of the most critical pieces of an estate plan for adults. Within your will, you are able to not only direct the way you wish your assets to be distributed, but also who you wish to care for your minor children in the event of both of their parents passing. A will is often the cornerstone of an estate plan and should always be drafted and reviewed by an attorney to ensure your goals will be met. With a will, when you pass, your will be probated, which means that your local probate court will handle the administration of the will and will ensure that all wishes found within valid wills can be followed. However, a will can be contested for a variety of reasons, and the probate process can be quite lengthy, especially if you have multiple creditors involved. So a will may not meet everyone's needs, and sometimes a trust is needed, which we'll discuss in a moment. A power of attorney allows you to appoint another individual, known as your agent, to take care of certain life tasks for you. Often these are financial in nature. We have found powers of attorney to be helpful if, for example, you're buying a home. You cannot be at the closing in person. You can appoint someone to take your place and sign for you at the closing as your agent. You can also appoint a power of attorney to make stock market-related transactions for you or apply for government benefits on your behalf. Before finalizing your power of attorney, you will want to speak with the individuals you have chosen to appoint to ensure that they are up for the appointment. Make sure that they're going to be okay acting in your place, signing on your behalf, things like that. All adults, everybody over the age of 18, should have a power of attorney, but they can be especially helpful for parents who know that they can't always do it all. Okay, a healthcare surrogate. It allows you to appoint an individual to act and make healthcare-related decisions on your behalf if you become incapacitated or are otherwise unable to do so. For this position, you want to choose someone who you trust that they would make a decision similar to what you would make if you were able. This means that you want to pick a trusted family member or friend, and importantly, you want to tell that family member or friend that you want them to serve in that role. You want to talk with them about the choices you would like for them to make and make sure that they're okay with accepting that responsibility and following through on making those decisions. Acting as a healthcare surrogate can be a very, very heavy task, so you want to make sure the person that you choose to serve in that role is not only willing, but they're able to make those hard decisions on your behalf. As we know, emergencies happen daily, and parents should have a healthcare surrogate in the event they wind up in a car accident and are unable to communicate, or if problems arise in the middle of surgery when they're under anesthesia. It goes much smoother if you've got a healthcare surrogate appointed and you've had those conversations with them ahead of time so they know not only what you expect, but it helps the doctors make decisions that are in line with your wishes and your values. A pre-need guardian is what appoints a guardian for your minor children in the event of your and their other parents passing. So the pre-need guardian can be done through a clause in your will or through a separate document, but it does require court intervention to be finalized. So therefore, because it does require that court intervention, it's important to have this discussion not only with your child's other parent, but also with the person or people you opt to appoint to serve in this role. This is a hard discussion for parents, as each parent usually has his or her preference for guardian, and they may not always be the same person or people. But this is one of the most important reasons to have an estate plan as a parent. And this is the conversation that my husband and I had that went much smoother than I anticipated, but it was one that I definitely dreaded having. So if you've got, a spouse or a significant other, or just another, the child's other parent that you're stressing about having this conversation with, I encourage you to do it. I stressed about it for a couple days before I finally got up the courage to talk to my husband about it. And in the end, we actually agreed on most things. So just have the conversation. I think you'd be surprised, especially when you're doing it proactively, how much if both of you can kind of talk through things together, how often you'll wind up on the same page at the end. So without an appointed guardian, the court will be responsible for making that decision as to who will care for your minor children. When you appoint a guardian, it gives the court guidance and it makes it a lot easier for them to ensure your wishes are met and your child is cared for by those who you intended. So if you want to raise your children with specific values, different educational background, you're going to want them to be with a pre-need guardian who shares those same values, who understands those values that you and the other parent hold, and can help effectuate those in your children in the event you're not able to be in your child's life anymore. Again, something nobody ever wants to think about, but it is important to have that conversation before, God forbid, such an event happens. Okay, so as mentioned earlier, a will does not cover everyone's needs. Some parents and non-parents will need a trust to set up to actually achieve their goal. So one of the benefits to a trust, and there are many, so that's always a conversation that I do have, especially with my platinum tiered clients ahead of time, about the benefits to a trust. I never push for it, but I do discuss the benefits of it and kind of let you know ahead of time, here's what you're looking at with a trust and what you can accomplish within that, and here's what you're looking at if we stick with just a will. So one of the benefits to a trust is if you have life insurance policies, the life insurance policies can appoint the beneficiary of the policy to be the trust. And so then the money paid out by that life insurance policy can be used within the trust for the care of your children. So it makes it a little bit easier. And the trust, when it's properly funded, can also avoid probate. So that means that without having to go through the probate process, your children and other beneficiaries often can access your assets even sooner and without court intervention. The thing is, because a trust is more robust protection, they are a bigger investment up front, but I will say they can still be less expensive overall, as they do avoid that probate and an attorney's fee at that stage. Probate 9 out of 10 times requires an attorney's fee in the state of Florida. And by avoiding probate and putting a trust in place, as I said earlier, it can help your beneficiaries access the money you've set aside for them a little bit quicker. So therefore, a trust with a life insurance policy funding may better meet your needs if, for example, the guardians you choose for your children don't have liquid assets, but you enrolled your children in private school. And all of a sudden, you and their other parent have passed away. The guardians are now in charge of the children. That private school tuition bill is coming due in August. They don't know what to do. They can't pay it up front because they don't have those liquid assets. A trust funded by the life insurance policy will allow the trustee of the trust to provide the money directly from the trust for school tuition, as long as that's been outlined in the trust documents. So a trust gives much more control and a lot more ease for your beneficiaries and your children. A living will lets you state your wishes about healthcare in the event that you are in a persistent vegetative state, if you've got an end-stage condition, or if you develop a terminal condition. On the living will paperwork, you can indicate if you wish to ever have life-prolonging procedures either withheld or withdrawn, and you can also designate a surrogate to carry out the provisions of your living will. Again, similar to the healthcare surrogate, you're going to want to speak with your appointed living will surrogate before appointing them, explain your wishes to them, and confirm that they're comfortable with serving in that role and effectuating the wishes that you wish to see happen. If they're not comfortable with it, they're not the right surrogate for you, and you need to go back to the drawing board and think about somebody else that would not only be trusted enough to be there in such an event, that would also be able to follow through on your wishes. Some special considerations for parents. If you have minor children, some of the things you'll want to consider include life insurance policies for your minor children in the event of your passing, who you wish to care for your children if something happens to you and your children's other parent, and who you wish to give the authority to make important healthcare and financial decisions on your behalf if you're incapacitated or otherwise unable to do so. So those are not easy considerations to make, and it may take you a few days to come up with the answers, but they are critical conversations to have not only with yourself, but your significant other, your children's other parent, and the individuals who you choose to serve in the important roles within your estate plan. I personally remember, like I said earlier, the dread that filled me when my husband and I were going through this exercise. I just didn't want to talk about who would care for our daughter. I didn't want anyone to feel left out or less than, but we had a constructive conversation. We agreed on our choice, and I slept well that night, knowing that she would be cared for. And again, as I said earlier, I was anxious for days before actually talking to him about it. And so, that was probably also part of the reason why I slept well that night, because I was up for several nights before having that conversation. So they're important conversations to have. They don't need to be done in 5 minutes. Especially if working with us, we understand that those conversations take time, and it's perfectly fine to take your time having those conversations because it's something you want to try to get right. As everything else with parenting, we're always trying to get it right for our children. So these are not conversations that should be had, when you're both tired after a long day at work, you're both laying in bed with heads on the pillow. Not the time to bring up, hey, who do you think should care for our children if, we both pass away or become incapacitated or otherwise unable to care for them? Not the time. Go out to a nice dinner, sit down, have a conversation. That's the way to do it. All right. So as I mentioned earlier, while we've always offered our virtual estate plan meetings and consultations, this week we've made it easier than ever to get started on your estate plan today, all from the comfort of your home. If you visit us at wildonerwills.com, you can learn about estate planning essentials, whether a will or a trust is right for you. We have a fun little quiz about that. And you can sign up and complete the initial interview, all without having to speak with someone first. Of course, if you're more comfortable speaking with us first, we do still offer that as an option. This new virtual option is helpful to parents or expecting parents who wake up in the middle of the night and cannot sleep because their brain won't shut down, so they want to use that awake time to do something productive. I know when I was pregnant with our daughter, I would wake up every morning from about 2 to 4 a.m. and I spent those 2 hours watching usually 6 episodes of The Office on Netflix. It was great, but if I could have used that time instead to get some of our estate plan done, that may have been a more beneficial use. So when you visit that wildonerwills.com site, there's a big Get Started button in the top right corner, and you can click on that and you can sign up and start telling us about your situation. You'll create a login so that you can save your work during the intake process and come back to it at your convenience. Or if you're ready for it, you want to sit down and finish it all in one session, that works too. Depending on the tier of service you choose, you may opt for an initial consultation before we draft your documents, or you may opt for us to draft the documents for you just based on the answers to the interview questions. Either way, we will always review them with you after to make sure they meet your needs. Like I said, even if you opt for the initial consultation, we have the same post-drafting review, again, ensuring your needs are met. Additionally, we are available by phone, email, Zoom, throughout the entire process and after. We don't just tell you to fill it out, we'll send you the paperwork and that's it. No. If you select one of our gold tier packages, we'll have you fill out the interview, we'll draft the documents based on your interview responses, and we'll review them with you. If at the time of review, the documents are what you want, we redo them. We'll redo all documents one time to get them where you want, and then we'll send them off for signing. At the platinum tier level, we'll have you do the interview. We do the initial consultation to make sure that the interview and what your wishes are reflect the same thing. We'll get the documents drafted, and then we'll do a review after the documents are drafted, again, to make sure they meet your goals. So as mentioned and discussed a little bit, we've got the 2 tiers of service. We've got gold and platinum. Packages under the gold tier will include the drafting of the documents and a review of the completed documents with you to confirm that your needs are met. As I said before, again, if they are not met, we offer 1 revision for free to get them right. Packages under the platinum tier include the same things, the drafting of the documents and a review of the completed documents with you, but they also include an initial conversation where we will discuss with you your goals. The platinum tier can be helpful for parents with a more complex asset or family structure. If you've got a net worth in excess of $1 million, or if you're in a second marriage situation, or if you've got stepchildren involved. That way, when we're having that initial conversation, we can discuss some of those things and kind of get a feel for what you may want to do. And we often can also mention some things that you may not have thought of before, but that may apply to your specific situation. So that's where the platinum tier is helpful because we do a little bit of a better job truly getting to know you and trying to get you to think of some things that you may not have thought of before. If you know exactly what you want to do, then the gold tier is perfect because that will allow us, again, the time to review it to make sure that your goals are met, that what you thought you wanted is what you wanted. And again, we do offer 1 free revision under both of the gold and platinum tiers to make sure you're satisfied with your documents at the end. All right, so while our prices are higher than the generic online document prep services, think LegalZoom and Rocket Lawyer, where some people say they can get a will for, I don't know, $30, which is crazy to me, it's for good reason. The online document prep services, they're not lawyers. A computer cannot understand nuances that an individual attorney can. Not to mention, a computer doesn't have a law degree, nor does it have the experience to see what happens to the families of those who use those services. So I personally am a price-driven shopper. My daughter's baby bows and outfits are very expensive, so I save money where I can. I can tell you that spending the negligible money on an online document prep service is going to be a waste of money. That can be better spent on a night out with your significant other or an extra couple of baby bows. I've made my services as accessible as possible because parents having a solid estate plan is something I'm very passionate about. So yes, they are a little bit more of an investment up front than a non-attorney computer-generated document, but they are worth more than that in the long run. If you use a computer-generated form as your will, there's no telling how the court's going to handle it. It may not properly appoint guardians for your children. It may not properly transfer your assets to your children or their caretakers, which would leave your kids and their caretakers in a financial lurch until they can get permission from the probate court to access your assets. There may be additional hearings that have to be held. It can be a mess. Not to mention, if your estate becomes contested while it works its way through the court system, the attorney's fee on the back end will end up eating some of the assets that you intended to go to your children. So while I don't encourage anyone to use an online document prep service, and it's not just because I'm an attorney, it's because I have seen the damage it can actually do. It can do more harm than good. I really implore parents of minor children to stay away. To me, there's nothing scarier than thinking my daughter will be taken care of, only to never find out until after it's too late that my documents that I thought met my needs actually created a tangled mess my daughter is caught in. So if you've got one of those LegalZoom, Rocket Lawyer wills, I don't review them because, to be honest, to clean up the mess from those wills is more work than to just start over from scratch. So our package prices are very, very reasonable. And it is because I am so passionate about parents of children being set up. It is still an investment, but it's something that is important. Just as we invest in our children's education, we invest in their preschool, it's important to invest in this part of it. Just because this isn't something that you see active live every day, it's something that you want to have set up for when it's needed. So it's very, very important. Please, please, please stay away from the Rocket Zoom or Rocket Lawyer and Legal Zoom. They do more harm than good. So after that impassioned plea, because of the passion that I feel for this, and because I'm so excited about our new service that we're offering for the rest of this month, July 2020, I'm offering a 10% discount code for our virtual packages, which is New Parent 10. So if you're interested in taking advantage of that 10% discount, please reach out to us before July 31st and let us know. In order to qualify and receive that 10% discount, the plan not only has to be chosen, but it also has to be paid for by the end of the month. So on August 1st, then those plans will be going back up to their normal prices. We may run promos in the future, can't guarantee it. But what I will say is, since it is new and since we are so excited about it, and I do want parents to really get their estate plans in order, we are offering the 10%. So for more information on how to get started, visit wildonerwills.com and click on the Get Started button in the top right corner. So thank you very much again for joining me today. And let me take a look and see if we had any questions come in. I don't think I saw any, but let me see. I know one of the common questions that I do get is whether you need a will or a trust. And that's a common question a lot of parents have, which is why I did make the quiz available on our website. The quiz is not foolproof, of course. You know, the only thing that is kind of foolproof is talking to an attorney. And even then, we don't make the decision for you. We just educate you on, in your particular situation, with your particular assets and your particular family structure, whether it's going to be better to go with a will or a trust. You know, again, a trust is a lot more robust, and it's something that most attorneys kind of push for. I don't push for it, but I do let you know, here's what we've got. You know, we can either spend a little bit more money up front and get the trust and get it properly funded and get it done and sleep well at night and know that everybody's going to be protected, or we can get the will done, still getting it done, but it's going to require more work on the back end for everybody. So that's the main, you know, kind of conversation that we have. But it really also focuses on what your asset and family structure looks like. Okay, so if you watched our webinar live today, or if you caught the replay during the month of July 2020 and you want to take advantage of our 10% discount, please do reach out to us, wills@wildonerlaw.com. We're happy to start working with you. We're happy to answer any questions that you've got. Here's our contact information. That's our Jacksonville office location, our office number, the email address that's going to get you in the right place for who can answer your questions about wills and trusts and estate planning is wills@wildonerlaw.com. Our main website is wildonerlaw.com, but the one that's got the links to our online estate planning virtual services is going to be wildonerwills.com. So if you have any questions, feel free to give us a call, send us an email. I really appreciate your time today. Thank you very much and have a wonderful, wonderful day.